Cybercrime Law under RA 10195. This is a table of contents. Introduction, Cybercrime Prevention Act of Philippines, the fundamentals of the Act, the key provision of Cybercrime Prevention Act of 2012, advantages and disadvantages of Cybercrime Prevention Act of 2012, the new Cybercrime Law harm free speech, conclusion. Introduction, the Philippine Congress enacted Republic Act number 10175 or Cybercrime Prevention Act of 2012, which addresses crimes committed against and through computer system of 12 September 2012. It includes penal substantive rules, procedural rules, and also rules on international cooperation. Mandatory bills on cybercrime investigation are under work in the Philippines, with new provision being introduced on procedural powers, responsibilities, and extradition. The aims is for the amendment to provide the structured approach for prosecutors and investigators of cybercrime investigation and to further align the national legislation with the Budapest Convention. In India, the Information Act of 2000 was enacted to regulate cybercrimes. The act is based on the United Nations Model Law on Electronic Commerce, 1996, recommended by the General Assembly of Act United Nations in the year of 1997. The Information Act 2000 was later amended in the year of 2008 to improve certain provisions of the original act. There is an emerging consequences among corporate criminologies, which is the corporate crime and violence inflict far more damage on society whole street crime combined. Heightened concern around this issue has been demonstrated by a number of recent conferences on commercial crime, staged by the Republic of South Africa. They can afford to offer hard-to-resist bribes to the law enforcers and bribes to do not work. They also afford to hire best lawyers in the world to defend them during the court litigation. More so, with the aid of modern technology, corporate crimes are mostly committed with sophistication that gave prosecutors a harder time to provide their guilt in court. The nature of Philippines corporate law is a direct transfer of American corporate law and is therefore a product of the common law system. The Philippines adheres to corporate code that provides for statutory principles. This development can be anticipated by way of jurisprudential rules that corporate principles adopted and applied to conform the charging concept and mechanism within the world of commerce. And aggravating circumstances result in the imposition of the penalty within the higher duration of the penalty provided due to the presence of particular circumstances, manifesting a greater criminal perversity of the accused as shown in the brutal excessive manner of the method which was consciously adapted to facilitate the commission of the crime, or taking advantage of physical or the flagrant disregard by the accused of special personal condition of the victim and other analogous circumstances.
Cybercrime Prevention of the Philippines. Cybercrime, also called computer crime, is the use of computer as an instrument to further illegal ends such as committing fraud, trafficking, child pornography, intellectual property violations, stealing identities, or violations of privacy. The difference between traditional criminal offenses from cybercrime is the use of the computer in committing such offenses. Majorly, cybercrime is an attack on the information of individuals, governments, or corporations. Cybercrime Prevention Act of the Philippines. To combat and prevent cybercrime, the government of the Philippines introduced the Republic Act No. 101175 or Cyber Prevention Act of 2012. This act was signed by the President of the Philippines, Mr. Benigno Aquino, on September 12 of 2012. The original goal of this act was to penalize acts like cybersex, child pornography, identity theft, and etc. Data interference. Unauthorized tampering with destroying, deleting, or deteriorating computer data, electronic documents, or electronic data messages, as well as the introduction or transmission of viruses. This provision can also cover authorized activity if the person's behavior went beyond the agreed-upon scope and resulted in the damages listed this provision. System interference. Unauthorized interference with the operation of a computer or computer network, including the introduction of or transmission of viruses by putting, transmitting, damaging, deleting, deteriorating, altering, or suppressing computer data or programmers, electronic data messages, or deleting, deteriorating, altering, or suppressing them. This provision can also cover authorized activity if the person's behavior went beyond the agreed-upon scope and resulted in the damages listed in this provision.
Child pornography is a form of child sexual exploitation. Federal law defines child pornography as any visual depiction of sexual explicit conduct involving a minor person less than 18 years old. Images of child pornography are also referred to as child sexual abuse image. Federal law prohibits the production, distribution, importation, reception, or possession of any image of child pornography. Corporate liability. In the eyes of the law, corporations are seen as persons or individuals who can be persecuted and liable for actions. Distinctly separating corporation, this way gives them the ability to own assets and take on liability separate from the owners or leaders of the company. Corporate liability determines the extent to which the organization is liable for the action of its employees. Traditionally, libel was a term governed by state law. State courts generally follow the common law of libel, which allows recovery of damage without proof of actual harm. Under the traditional rules of libel, injury is presumed from the fact of publication. However, the U.S. Supreme Court has held that the First Amendment protection of freedom of expression limits a state's ability to award damage in action for libel. act of libel that are illegal or forbidden under Article 355 of the Revised Penal Code as amended and are committed using a computer system or any other similar means that may be created in the future. Penal Code revision according to Article 355, libel is defined as defamation of character by writing or other means, libel committed by writing, printing, lithography, engraving, radio, photography, painting, theatrical exhibition, cinematography, exhibition, or any other similar means is punishable by prison correctional for the minimum and medium periods or fine ranging from 200 to 6,000 pesos or both. In addition to any civil action that the offender party may bring. Cyber squatting. Acquisition of domain name in bad faith on the internet to profit, deceive, harm reputation, and prevent others from registering it. These include trademarks that we already registered at the time of registration, names of people other than the registrant, and trademarks that we were purchased with intellectual property interest in them. Those who get domain names of prominent brands and individuals who in turn are used to damage their reputation can be sued under this provision. Cybersex. For favor or consideration, willful engagement, maintenance, control, or operation directly or indirectly of any lascivious presentation of sexual organs or sexual activity via a computer system.
Advantage: cybersex, cyberbullying, child pornography are now offenses and such offenders can be punished. The children's rights are protected by this act. All kinds of business using the internet as a medium are protected by this act. Provision of this act now define the offense of cybercating and this deters people from the act of cybercating. Provisions that penalize online identify theft. This provision protects the individual's privacy and its protection. First disadvantage: ambiguity in the terms given in the act, such as the term online libel is not defined anywhere, which can lead to different interpretation. Ambiguity can be seen in the provision of real-time data collection. Second disadvantage: the ambiguity in the act may lead to the freedom of speech. The ambiguities, like the absence of a proper definition of online libel, may lead to confusion. Sometimes the expression of some truth may be misinterpreted as libel. People may be restrained from expressing themselves. The implementation and execution of this act yearly costs a huge cost to the government. For purposes of this act, the following terms are hereby defined as follows. A. Access refers to the instruction, communication, storing data, retrieving data, or otherwise making use of any resources from a computer system or communication network. B. Alternation refers to the modification or change in form or substances of an existing computer data or program. C. Communication refers to the transmission of information through ICT media, including voice, video, and other forms of data. D. Computer data refers to any representation of facts, information, or concepts in a form suitable for processing in the computer system, including a program suitable to cause a computer system to perform a function, and includes electronic documents and electronic data message. whether stored in local computer system or online. E. Computer system refers to any device or group of interconnected or related devices, one or more of which pursuant to a program performed automated processing of data. It covers any type of devices with the data processing capabilities including but not limited to computers and mobile phones. F. Criminal infrastructure. It refers to the computer system and networks, whether physical or virtual, and traffic data so vital to this country that a capacity or destruction of the interference with such system and assets would have a debilitating impact and security, national or economic security, national public health and safety, or any combination of those matters. Punishable acts, cybercrime offenses. The following acts constitute the offense of cybercrime punishable under this act. First, illegal access. Second, illegal interception. Third, data interference. Fourth, system interference. And last, misuse of devices. Will new cybercrime law harm free speech? A new Philippine cybercrime law drastically increases punishments for criminal libel and gives authorities excessive and unchecked powers to shut down websites and monitor online information. Human rights was said today.
Will cybercrime law harm free speech? The criminal penalties and other restrictions of law are a serious threat to free expressions in the nation. Several legal cases have been filed in the Supreme Court of the nation and demanded that this law be declared unconstitutional because it violates guarantees to free expressions contained in the nation or Constitution of the Philippines and human rights treaties ratified by the nation. Brad Adams, Executive Director of Human Rights Watch Asia Division, said that the cybercrime law needs to be repealed or replaced. It violates Filipinos' rights to free expression and it is wholly incompatible with the Philippine government's obligation under international law. Conclusion: a comparison between the Cybercrime Prevention Act and the policies of Philippines and India shows similarities to some extent, and at the same time, there are slight differences if the provision of cyber libel in both countries are compared. It can be seen that both countries include this provision and immediately attracted the difference of opinion from the netizens. In India, the Information Technology Act of 2000, Section 66A defines the penalty of sending offensive messages through the computer, mobile phones, or tablets. Because the government failed to define the term offensive, it began to be used to suppress freedom of speech. In the year 2015, the Supreme Court overturned this law. In the Philippines, the same uproar from the netizens was heard when the cyber libel was introduced as one offense under the Cyber Prevention Act of 2012. In Disney, Secretary of Justice, the validity of the rule on online libel was challenged. The Supreme Court, on the other hand, determined that libel is not protected speech under the Constitution. As a result, the internet libel is not unconstitutional. There may be different approach to the provisions of the Act by different countries. Nevertheless, to say that strict enforcement of the cyber libel law is essential to combat cybercrimes. Technology crimes are not just limited to a geographical region, but it is a global phenomenon, and stringent cyber law are essential across the globe. The state also recognized the importance of providing an environment conducive to the development, acceleration, and rational application and exploitation of information and communication technology, or ICT, to train or attain free, easy, and intelligible access to exchange and delivery of information, and the need to protect and safeguard the integrity of computer and communication systems, network and databases, and the confidentiality, integrity, and availability of information and data stored therein for all forms of misuse, abuse, and illegal access by making punishable under the law such conduct or conducts. When any of the punishable acts herein defined are knowingly committed on behalf of or for the benefit of a juridical person by a natural person acting either individually or as part of an organ or juridical person who has a leading position within based on a power of representation or juridical person provide the act committed falls within the scope of such authority. B. Authority to take decisions on behalf of juridical person provide that the act committed falls within the scope of such authority. Or C. An authority to exercise control within the juridical person. The juridical person shall be held liable for a fine equivalent to at least double the fines impossible in Section 7 up to maximum of 10 million pesos. The regional trial court shall have jurisdiction over any violation of the provision of this act, including any violation committed by a Filipino national regardless of the place of commission. Jurisdiction shall lie if any of the elements was committed within the Philippines or committed within the use of any computer system wholly or partly situated in the country, or when by such commission any damage is caused to a natural or juridical person who, or at the time of the offense, was committed in the Philippines.